Welcome back, everybody. We are back, September 23rd, 2017, and we are now here. Sitting to my left is attorney Benton Ross Watson. It's being sponsored
Woo!
by Coppolino Dobb Krebs Law Firm, and we are just so thankful for that. And attorney extraordinaire Benton Ross Watson, I'm telling you, you're paying my medical bills, dude. That's right. Don't look at me like that. I'm carrying satchel bags.
I thought you had a case with Rick or something.
All this fan mail, man. Have him email it to you or something. All right, here we are. We're here today, and we're talking about Penal Code 941 and 942, protection of one's own property and deadly force to protect one's property. And we do this periodically from time to time because so many people, you hear it, then you go, what can I do? I go, first of all, study your books. But I know you're not going to, so that's why I'm here. We're going to repeat, every now and then, what's going on and explain the do's and the don'ts, the cans and the can-nots, and all that kind of stuff. So,
yeah,
Ross,
we've talked about how many thousands of, and really into the millions of laws that there are in a couple of episodes, and I just busted my pen again.
You're thinking about your girlfriend.
So, yeah. And so the legislature has tried to, through codification of these laws, take into account for so many situations, but I can understand why people read this and don't want to read all of these provisions because, there's so many instances in life that, you can't put down in black and white, and they're hard to account for.
And I've learned from you guys, you and Rick, that even though it's in black and white, the part that is in black and white, it almost doesn't mean anything. It almost doesn't mean anything because it's like the personality of the judge, what they enter into court, the attitude of a juror. I mean, don't do it, everybody. Wait till the last minute before you have to use that weapon.
And that's exactly right. That's probably the best advice that you can give.
Mark that down.
I understand that there's going to be the environments and circumstances where a person is going to. It's not going to feel the same. We can sit here and say that. Oh, you wait till the last moment, but
Well, everybody's last moment is different.
Different, exactly. And so even that has a different meaning, and what somebody thinks may be the last moment or what may be necessary, okay, is going to be different in every case. And that's so why when we talk to jurors about any kind of self-defense case, one thing we go into is you're looking at it from what the defendant's, my client's point of view. What did my client think was necessary immediately in those circumstances?
Mm-hmm. And you got to convey that to have other people believe it.
And so one of my favorite things to say is that, the state's going to get up there and say, well, it's got to be a reasonable belief. And they always talk about a reasonable doubt. Doesn't mean beyond all doubt. Well, is anybody here paranoid?
Not me.
Is anybody here psychotic?
Well, that might be the case.
I mean, we may have some problems, but for the most part, if you have doubts and you're a reasonable person, it's a reasonable doubt.
There you go.
Okay, and so if there's any reasonable doubt, even one, then the verdict's got to be not guilty. Okay, and so it's the same concept. Is my client a psychotic just because he got into a fight, or just because he was involved in this situation? Like talked about what happened with me just about a month ago. I mean, I had nothing to do with that. I was trying to get out of there. I mean, so a lot of times good people are put into bad circumstances, and they have to figure out a way to get out of it.
But the more prepared you are, hopefully through shows like this, the less problematic it will be as if you got to go to court.
Right, and so like you said, if you always have it in your mind to wait till it's absolutely necessary, right, then at least you're going to try to wait till it's absolutely necessary. And that may be different for you, but that's what you can argue.
Okay, Ross, I want to ask you, I want to set this up first. There's a lot of terms in here that people ask me all the time. And I want to hear from you if you're okay with this. Because I want to use the terms that you're going to give definitions to as standby blocks of information when it comes into the story of somebody having to defend themselves. If they've got these bits of information that are not deniable, you can't deny it. It is what it is. It means what it means. And let me give you an example of one. What is tangible, movable property?
Well, we haven't gotten into...
listen to all this stuff that we're going to talk about and just make notes so that when you apply your storyline to it, you have definitions.
So again, we've talked about self-defense. It's self-defense of a person, of yourself, of another person, okay, of your child, wife, whatever. But today we're talking about defensive property. I'd like to start at, some people would say, well, why do we need defensive property if you can defend yourself? Well, sometimes somebody trying to take your personal property, okay, or other times you're on your land, and some people would say, well, why, if you're on your land, we already know that you get the presumption to use self-defense, and it's not even, arguably, they can't even arrest you, and it's not even affirmative defense so much as it is a complete protection, that you're authorized to use force when you're in your house or on your land and somebody's coming into it. Well, even if you get into one of those instances, and that's not necessarily true, but even if you're there, remember, the self-defense code talks about an occupied residence, an occupied vehicle, an occupied place of employment. And so it sort of gives this implication, and we don't know for sure yet, and what I was saying is a little vague. It sounds specific, but it's not really, okay? But it gives this implication that maybe you have to be there. And so what if you come home and somebody's there and there's nobody else at your house? It was in the middle of the day. I gave this example last year when we had a show on a similar topic. So if you come home and somebody's robbing your house, technically that house wasn't occupied. Maybe the cat, okay? But I don't think that's what the code is talking about. And
see what I mean? Black and white isn't black and white.
Right. And so we get there, and now if you go in and do something, can you really use the self-defense provision? Well, it was an occupied residence. You sure don't get the presumption. And so your lawyer is going to want to also tack onto that defensive property. Okay, and so we go, and this is where we are. And the code talks about, in the first instance, in Texas Penal Code section 9.41, it talks about a person who is in lawful possession of land or tangible personal property. Okay, tangible, I think, comes from tangere. I think some folks would tell you about...
Is that Greek? Latin?
It's Latin. It's Latin. Yeah, yeah. Noli me tangere, touch me not, don't touch me. Okay, so comes from tangent, meaning touching the point, a tangent vertical point that's touching, abutting to something. So it's tangible personal property, something that's palpable, something that we have, we can move, and that's why they added that qualifier on their movable property. Now, yes, we can sit here and we could take all the time trying to come up with what property could be tangible and not tangible. Stock typically is not technically a tangible property, but you could classify that down into a certificate of stock.
Does this relate to like real estate, where if it's not attached, like you got plants, you can't cut the plants down and take them because then you're taking the...
And you could argue it's a fixture, right? You could argue, is it a fixture to real property? But if the burglar has gone in and removed your sink, which was probably a fixture, at this point, is it still classified as land? I don't know, but either way, I don't think it's going to matter. Okay, you're going to be entitled probably to the same defense unless he actually gets off and out of that house. Okay, and so it's just going to say that the subsection A is talking about being in lawful possession, and so I take this to mean we're at home and we have somebody come in and trespass into the house, and because it speaks to, we're going to prevent or terminate, we're going to stop an action, right, that's maybe just beginning or just in progress, okay, and we're going to stop it before it's consummated, before it's in completion, before that thing is complete, okay, and so we're going to terminate or get we're going to get out in front of this thing before it actually happens or gets to a point that it has, you would say this act is finalized, okay, and so we're going to, maybe if we walk home even, maybe we haven't technically been in lawful possession, but we haven't actually lost any of our personal property yet that's in that house. So maybe we go in the house to use force to prevent him from dispossessing us of our property. When I say him, I mean the burglar, the thief, or the person we think is the burglar or
Can't
thief.
somebody say you're escalating?
Well, and so
because you weren't in the house, you weren't occupying, but you went in to occupy.
It's my house. I think I have a right to go inspect what's going on my property.
I granted, but like I said, black and white ain't black and white. So I'm just saying.
I think I definitely have a right to go in and inspect my property and see what the heck is going on when my door's wide open. It looks.
Do you even really need a reason to go into your own home?
That's exactly what I'm saying. Do I even need a reason just to go into my own house? If the law is trying to tell me that I do, then I mean I do think the law is unreasonable, and that's why I do what I do. But I think that we've gotten to a point where we have no reliability whatsoever in the justice system, if they're telling me I can't go onto my own property.
Okay.
So I think absolutely my answer is that yes, you can go on your property. I can see there be some kind of liberal and even some crazy conservative, a super crazy conservative would say, oh, you should have just automatically called the cops when you saw your door broke down. Man, that's great, but that's just not how life works. Okay, and I have absolute right, I think, to go on my property. And in my property, especially my house. Okay, and so when I go into my house, right, that's what this code tells me. I have a right to terminate or prevent the other's trespass on the land or unlawful interference with property. I can go in, okay, and inspect, and that's not using force at all whatsoever. There's no way the law could tell me that I didn't have a right to go in my house. Okay, and so once I go in my house, right, if I see him trying to take property, at that point I can use force to subdue the trespasser or the... That's what the shopkeeper's privilege is about. There's Rick Dodd would be a great one to ask about this. This is kind of a civil case. He's done some civil assaults. Okay, well, this is what the shopkeeper's privilege. When you go in and you're trying to shoplift, that security guard or even an employee there's got a right to use reasonable force to detain you and prevent you from leaving the store and prevent you from taking that property.
Okay.
And so they've got an actual right to subdue you, and like I do, and I can use that force, okay, to prevent that interference. But what happens when the guy gets out of the house and he's running away with this property? Now the code has this second section, the subsection B, talking about unlawful dispossession, and I have a right to re-enter the land or recover the property if the actor uses the force immediately or in fresh pursuit. If I use this force immediately or in fresh pursuit. Now, what is fresh pursuit? Fresh pursuit goes back to these old English common law days from the England courts, and what is equity and authority from the king versus from the courts of the church, and then later the courts of law. Okay, and so it goes to an officer going outside of his jurisdiction. Also, we talk about when we have a police officer that maybe didn't have jurisdiction to go into Arkansas. They can use fresh pursuit if they've been chasing that defendant from Texas. They can go into Arkansas because their jurisdiction is kept alive by reason of the chase. Okay, and so that's the same is true with your house. On the Fourth Amendment, a police officer can't go into your house. But if he's given chase immediately from the scene, he's seen you commit this, okay, then he's got a right without a warrant to enter your house because he still has the authority by reason of the chase. His authority is kept alive, and it's also under the exigent circumstances, emergency circumstances provision. At that point, it becomes an emergency situation where the officer's got a right to chase. The same is true for you in these types of instances. I have a right to give chase to protect my property, but if there is, it's got to be continuous. If there's some kind of unreasonable...
Does continuous mean any type of distance?
That's going to be a fact question. I know you want an answer, but I can't give you one. There's going to be a fact question. I think.
That's my answer. My answer is I don't know. So my safety net line would be property line per city block.
I don't think it's necessary that maybe you lose sight of the person. I think if he ducks around the corner, I think if you keep chasing, right, and maybe you lose him we all watch those cool cop shows when they're facing folks. I mean, it's almost every cop show.
They got a badge on though.
But it's the same. It's the same kind of situation to go get your property. It is the fresh pursuit, right? Is interpreted maybe not constitutionally interpreted exactly the same, right? But for the purposes, that's going to be the same type of definitions that we're going to get in. So if they've got a right to chase, we've got a right to chase. But remember, if you don't have a license to carry, okay, and you're carrying a handgun out here, we've talked about those cases that I don't agree with, by the way, and I don't know how they'll play out under some of the new rules, but I said be very careful because that doesn't necessarily entitle you to take a handgun out in the public if you don't have a license to carry. And so that's another reason why you should have a license to carry.
Ladies and gentlemen, this is an excellent segment here. If you have any questions, 254-697-6633. You're crazy if you don't call. You've got an attorney here who knows his stuff. 254-697-6633. Go ahead.
But so I'm going to get to the point. The other section is not as difficult because this one applies to the other section as well. But not only do those things have to be true, not only does it have to be fresh pursuit, then you've got if right? And the actor, meaning you, reasonably believe the other had no claim of right. Well, obviously, if it's your property, they're not going to have a claim that they had a right to take it. Okay, obviously, if it's a burglar, you're gonna, or it's a guy with a hoodie on that you can't see, and you know, unless you're in some kind of divorce case that's getting nasty, all right, and you're hiring me or Michelle Lemkill or somebody like that. I think Rick was smart. He got out of the family law business a while ago, but I think you can get into one of those maybe where there might be some gray area. Maybe you're feuding with family, but if that's going on, maybe you should call in before you give chase. But otherwise, anybody's going to know that the other person's not going to have a claim of right. There could become instances in business type of situations, though, where maybe somebody thought they had a lien, okay, on a piece of property. Maybe when a tow truck driver pulls up to take this property, exactly what's going on. There was actually a good case where a guy thought his girlfriend's car was being stolen, and it was a repo guy that came up to get it, and he used deadly force against the repo man. And sure enough, he got charged for that, and he was able to assert a jury charge, and the trial court denied it to him because it said your girlfriend didn't have a right to use it. But he said, well, I reasonably believed there was no claim of right. Went up on appeal, they said he had a right to make the claim to the jury. I think that there's more complex than what I've given today, but...
That's why repo guys make a lot of money, huh?
Yeah, well, I guess, that's part of the job.
Part of the risk.
And then so, or the other accomplishes it through force, threat, or fraud, meaning the thief or the burglar uses some kind of force, threat, or fraud to accomplish the dispossession. And I don't think I need to go into that. You're going to know what the force or the fraud or the threat is to use it. Is such, maybe he has a hammer and he says, if you don't let me get out of this house, I'm going to kill you. Okay, well then you let him go, okay, then you got a right to give chase maybe with your own hammer. All right, and so at that point, that's getting into the deadly force area, and this is where we're going with this. So we get into section 9.42, and it says you've got to be justified under those provisions that we just talked about. Okay, you got to be justified under 941. And when you reasonably believe that deadly force is immediately necessary. And I want these words mean things. Okay, and so listen to these words. To prevent the imminent commission, meaning imminent, it is on the verge of happening right now. The commission, the completion of the whatever act is about to happen. So to prevent, meaning it has not happened yet, but it's imminent, it's about to happen, it's on the verge of happening. Arson, burglary, robbery, aggravated robbery, theft during the nighttime, criminal mischief during the nighttime. So, burglary is entering a habitation unlawfully, right, with the intent to commit a series of items which can be of violence, okay, or theft. Okay, so entering a habitation to commit a theft would be burglary. That's burglary.
And just for clarification, if you weren't intending to burglarize, but you went in there, that's just trespassing. Would that be the separation between the two?
Exactly. Okay. And actually, let me get through this first. Make sure I get through it. But there's a good case on this, and I want to talk about it before I get out of here. But you reasonably believe these things, so it doesn't actually have to be actual robbery, okay? Or burglary, but it's got to be a reasonable belief, okay, that you are preventing the commission of it.
I got you.
Okay, and so prevent. So if it has already been done, if it has already been accomplished, then a good argument from the other side is going to be, and I say the other side, I mean the prosecutor, is going to be that provision does not apply because it has already been done.
Wow.
Okay, and so we go to the next subsection, which is to prevent the other who is fleeing immediately after committing one of those things. So this time it has already been done. The act has been completed. This person has committed burglary, robbery, aggravated robbery, theft during the nighttime. By the way, it leaves out criminal mischief on this second provision. Okay? So fleeing immediately after committing burglary, robbery, aggravated robbery, or theft during the nighttime. If you remember, the previous subsection said criminal mischief during the nighttime. So if you're coming in and a guy just started the first letter of his graffiti, okay, or something to that effect, and is destroying property, you probably have a right to stop him. Yes, he has completed some of the destruction. right? But it is obvious that he is continuing to do it. So he has not completed his full act of the destruction, which could make a difference whether it's a felony, a misdemeanor, class A, B, C misdemeanor, okay? Because, $250 worth of damage is a whole lot different than $5,000,
Right.
okay? And so you can prevent this, right, further destruction of your property. But if it's done, and so criminal mischief, the property's done, it ain't being taken, it's just being destroyed. Okay, so if the person is taking the property now, he's completed the act of burglary, boom, he's bolted out the door, you see him bolting out the door, there he goes with your property. Is he escaping with the property, and you reasonably believe that has happened, and you reasonably believe, right, that he's committed one of those things and he's escaping with your property, and you reasonably believe that the land or property cannot be protected or recovered by any other means, or you believe one of these two things, the use of force other than deadly force to protect or recover the land or property would expose you or another to a substantial risk of death or serious bodily injury. In other words, you can't get this property back, or you're going to get somebody hurt if you go try to get it back. Okay? And so you asked me a good question a year ago, what about insurance? I still don't know. I don't know. There's no way for me to interpret it. We haven't had a case in the last year.
Well, you know the question I asked, and I know the question you asked, but let's reiterate it.
So can land or property be protected or recovered by any other means? My argument is insurance doesn't protect that piece of property if I can never get that piece of property back. Insurance does not recover that piece of property. That piece that was stolen will never be recovered. Your argument is, yeah, but it does protect the value of that property. And I said,
that wasn't my argument. I'm just using it as a.
I'm giving you a hard time, right? So I don't know. I think they're both good arguments, okay? And I don't know what's going to happen, and this is why you have a lawyer. But this is why we also have, or I just hit my tooth on the microphone, or. Right, the use of force other than deadly force to protect it would cause substantial death or bodily injury, serious bodily injury to another person. If it's covered by insurance and that argument works, you're never going to get to number two because nobody ever has to go recover that piece of property.
Ladies and gentlemen, you must sign electronically an affidavit now that states that you understand these laws. You've been told these laws, you've learned these laws, you understand these laws. Now look at how complex they can be under a situation, especially if you're stressed out. You better pay attention. And I argue, give us a call. You better read your laws and get them learned.
And I argue that the insurance argument though is a slippery slope because, there are some things that cannot be recovered. It ain't the value that I want to protect so much in my family heirloom.
See, the way you
nostalgia.
The way you term it though, Ross, makes it clear. I cannot replace that item, serial number such and such and such and such. I could get another, but it's not that one. So when you say it like that, it makes it so clear, but it gets muddled in the fight in the courtroom.
Right, and so how are you gonna, there are some things that cannot be replaced, but that's what I was trying to tell you. If it is just, if it is something that can be replaced, if it's a PlayStation they're leaving with, if it's a TV or something, don't try to make new law. Just let it go. If you've got insurance, let it go.
I agree.
Right, and fight another day. But if it is something that is so important, or it's a priceless item, okay, then that may give you a right to argue too, even if insurance could apply, right? It don't apply in that situation because I can never get that priceless item back.
Right.
I can never even go buy that item again, and then the state never even has a chance to make this argument, right? Or if they do, it's completely unreasonable. And so this is what I'm saying. Try to not push these limits. And if you do, I'll try to protect you, okay? But you're probably gonna need help protection.
You said something, and I'm not trying to be funny here, but just what's priceless to one person,
exactly,
is not to another. So, say for example, you've got this picture. It's just a basic picture. You can replicate it very easily. But your daughter or your son wrote on it, "Daddy, I love you," in his or her third grade crayons, and you can never get it back, and it's an emotionally attached item to you, and somebody's taking it. See what I'm saying?
Yeah, exactly. That's what I'm trying to say. No value. They're probably not even worth anything. Probably has no economic value. Okay, but it has value to you.
That's right.
Right, and so that's exactly what I'm getting at.
Okay.
We have 1 minute. Well, be careful because there's a case called Adami, and there was some illegal aliens in the house, and the man walked up, and as he was hunting,
You're talking non-documented workers, right?
a non-documented
Whatever.
foreign
Illegal aliens, man.
Yeah. And so he comes and sees him in his house, and sure enough, he fires off on him, and he gets charged with murder. So you have to be very careful about exactly if it was necessary to protect your property, if it was necessary to take the action. And nothing is going to protect a purpose to inflict pain or harm or malice, use malice against somebody, if the main purpose is not actually to protect that property. So even if you did use malice, you better make sure that you're able to put on a good case that you were actually just protecting your property.
Ross, you're fantastic. Tell everybody how to get a hold of you.
254-605-4140 is my number, 254-605-4140. I'm here in Cameron. My main primary office is 105 East Main Street. Again, here in Cameron. You can just ask people around town, too, if you need to holler at me. Benton@watson.legal. Benton@watson.legal. Thank you guys for having me.
Stop sending all these paper letters of fan mail. Send it email directly to Ross. Ross, can't thank you enough.
Yeah.
Take care until next week.